Do I just push the middle one? I think so. I think Kay has to do the first advanced slide. Kay was saying if she...
We are ready for roll call whenever you're ready. Yeah.
I see.
There you go.
Thank you. Okay. So we're calling to order the, I apologize, the date, the February 27th work session for the Historic Review Board. And I believe we're having a presentation by Carrie Richter tonight.
Thank you, Board Chair Ferry.
Can I interrupt just 1 second? Can we do roll call just for the minutes?
Of course.
Thank you.
Board Member Green? Present. Speaker Button?
Present.
Board Member Edgar?
Present.
Board Member Lawrence?
Present.
Vice Chair Powell?
Present.
Chair Ferry?
Present.
Thank you. All right, thank you. Just, I guess, a quick word. So this is our first in-person meeting in a long time, and so we'll work through the technical challenges and get used to the new room. So thanks, everyone.
So thank you, Chair Ferry and Planning Director Aquila. Sorry, heard Ravish. My name is Carrie Richter. I am the Deputy City Attorney for Oregon City, and I have been the part of the City Attorney team for over 20 years. I am also a trained historic preservationist, so when historic preservation questions come up, I'm usually the person who fields them, and I'm usually the person who comes to meetings when folks feel like legal support would be helpful. So I want to introduce myself to all of you who don't know who I am. My plan for the next hour or so is to provide a little bit of legal training. Some of you are familiar with the process, and some of you may be brand new to it. So I'm going to try to educate everybody and hope that there's something that I tell you this afternoon that you didn't already know, for those of you who are returning fans of this program. So with that, I'm going to move through about 14 slides. I encourage you to ask questions as we move along. I want this to be a fairly informal meeting, and I want you to have an opportunity to ask me whatever questions come up. I mean, this is your opportunity to stump the chump, so please take advantage of it. I don't know what I'm doing, okay? I didn't just move that, you did it. The top? Oh, I don't know. How would I know if it's on? Oh, yeah, it's on. Okay, I got it. I'm good. All right. Oregon was one of the very first states to adopt a statewide land use program, and that program celebrated its 100th birthday last year. 100th birthday, right? 50th birthday?
Yeah.
I knew it was one of the two. So last year it celebrated its 50th birthday, 50th anniversary of its existence. And the way it works is that there are statewide laws that govern how Oregon does land use and how local governments have to do land use. And then those are sort of broad principles. And then the cities kind of fill in the gaps the way they want to create their own program. And so the way the structure works is we have the federal constitution, which we have to abide by. We have to abide by the federal laws that are applicable to land use, which are generally the Fair Housing Act and the Americans with Disabilities Act. Those are the ones that come up in addition to the Constitution. So we've got to comply with that sort of overlay of obligations. Then we have the state laws, Oregon revised statutes, which provides standardized land use procedures. So all of the hearings you have are the procedures that govern those hearings are set by state law. And a number of special use protections, particularly farmland and housing are special use protections that are provided in state law, but there are a couple of historic related ones. Owner consent, for example, is in the state law that says that owners have to consent to a designation. And then there are administrative rules, which are adopted by the Land Conservation and Development Commission, which is an agency charged with implementing statewide land use goals. And they have done that by identifying goals 1 through 19. Goal 1 is citizen participation. Goal 2 is exceptions and coordination between different layers of government. Goal 3 is farmland. Goal 4 is forest land. Goal 5 is historic preservation, as well as other natural resource and sort of livability values that we have throughout the state. There are economic development related goals, like Goal 12 and Goal 9. Goal 12 is the transportation goal. So all of these sort of general principles are set forth in these LCDC goals, and then it is up to local governments to implement those goals consistent with state law. And the local governments do that by adopting a comprehensive plan and then implementing that comprehensive plan in their zoning regulations. There are other agencies that have rules too. Oregon Department of Transportation has rules, Department of State Lands has rules that relate to wetlands, but for purposes of HRB review, the goal that is most relevant is Goal 5, historic preservation, and then there are administrative rules that say how local governments have to implement their historic preservation program, and that is set out in 660.023. There are requirements, there are regional requirements from Metro. Metro establishes the urban growth boundary that affects the Portland region. Metro identifies areas for growth where the urban growth boundary may expand, and they have a functional plan that identifies how areas are urbanized from county rural areas all the way through. And then, as I mentioned, the city standards, comprehensive plan and map, and the Oregon City Municipal Code, and then the Oregon City Zoning Map. And the purpose of all of these local regulations are to further a series of, competitive and complementary goals. We're trying on one hand to increase livability, right, through historic preservation or for stream conservation, while at the same time furthering economic development by zoning certain areas industrial, by encouraging commercial development in certain areas. We're trying to protect resources. We're trying to have orderly and efficient uses of land. All of those things, all those objectives are worthy goals, and we try to balance those in a way as they're set forth in our comprehensive plan and then implemented by our land use regulations. So that's the sort of big picture of how the comprehensive plan plays into the larger regulatory scheme. And so when you are looking at an application, you are looking at the comprehensive plan and the zoning code or municipal code to ensure that the application complies with those things, but those things already fit within the bigger structure of the statewide land use goals and all of those objectives. So there are a bunch of different laws at play here, but ordinarily we have by adopting the code, the city has essentially obtained approval from the state agency, the Land Conservation and Development Commission, that the code complies with the goals. So that's why we don't have to apply the goals every time we do a review, because once we adopt the code, we send it to LCDC, and LCDC, it's called acknowledgement, acknowledges the code as being in compliance. So we don't have to go back and review whether or not the municipal code provisions comply with Goal 5 every time, because we've done that when we first adopted it. So there are two I had this, okay, now I have broken it. Thank you. So in Oregon City, there are two baskets of land use reviews. There is long-range planning, the legislative type of reviews, and then there is quasi-judicial or administrative type of reviews, which are the development reviews. So long-range planning is when the Historic Review Board decides to amend its code to change the types of protections that it's going to give to certain types of resources. So in other words, legislative, this kind of decision-making is policy-making. You are setting the preservation policy for the city, so you are making laws. You're like a little legislature, saying what the preservation policies should be within the city. So when the city adopted a new comprehensive plan, that was a legislative decision because it was setting the policies. We are making the regulations and setting what they will be. In legislative decision-making, the city commission makes the final decision because they're the elected officials and they're the ones who adopt the code. And there is a special legislative process and that the code calls for proceeding through, but it's political because you're acting as sort of a political body. So you're supposed to go out and talk to the community about what they want to see with the preservation policy, and then you come and you discuss amongst yourselves and decide what that policy should be. That is to be contrasted with development review, a quasi-judicial review, which is you sitting as a judge. And when you're sitting as a judge, you are reviewing a specific application for a determination of whether that proposal satisfies the criteria, the policy you've already set. So this is, instead of being kind of wheeler-dealer political determination, this is you sitting as a judge making an unbiased evaluation of the evidence that you hear during the hearing, your review of the record, which is all the written materials that are submitted in advance of the hearing or during the hearing, and a determination of whether or not the criteria that are set forth in the policy of the code are satisfied. So there are a whole bunch more procedural protections that come with a quasi-judicial review than with a legislative review. And in quasi-judicial reviews, the Historic Review Board, in the case of an application that is subject to Historic Review Board review, that you all are the final decision maker unless a decision is appealed. So you get to have the final say on whether or not the proposal satisfies the standards. And we'll talk through what the formal quasi-judicial procedure looks like. Questions about that? So breaking down the quasi-judicial procedures to a little finer point, there are sort of four categories of quasi-judicial decision-making in Oregon City. The first type is for an administrative review that happens behind the counter in the planning office, where an applicant comes with a set of plans that shows a building, and the city staff looks at the building plans and says, the code says you have to have a setback of 5 feet. I'm looking at these plans. I see you've met the 5-foot setback, so we check that off the list. There's no reason to come before the Historic Review Board to determine whether or not the building is set back 5 feet, because everyone measures 5 feet the same. There's no discretion necessary to decide if the proposal actually meets the 5-foot setback or the building's 35 feet high. We don't come before you to ask you if the building is 35 feet high. We delegate that to city staff because there's no discretionary decision-making required for that kind of decision. So if you file an application in Oregon City and you're outside a historic district, or you are non-contributing and you're not altering the building, and so it doesn't require Historic Review Board review, staff goes through administrative type 1 decision and signs off on it, and you get your building permit and you're off to the races. So that's one way the review happens in Oregon City from a land use perspective. The type 2 decisions require a little bit more discretion. These are decisions that are, for example, you want to build a house on a steep slope. And so you have to have a geologic hazard analysis by an expert, and the city has a geologic hazard and consultant who reviews it and says, yes, it's okay, you have used all of the appropriate stabilization techniques so you can build on this slope. So land divisions are type 2s. There's a little bit more discretion in some of the land division decisions, so a subdivision. And these type 2 decisions are still staff decisions. They're made by staff, but there is a limited notice that goes out to neighboring property owners, and there's a right to appeal the staff decision to the city commission. So these are, again, not historic review cases. These are site plan review, land divisions, and geologic hazard reviews, I believe. So the action for the Historic Review Board is in the type 3 category. And in the type 3 category, we have the discretionary review to determine compliance with the criteria. And these are the reviews where you're reviewing an application for new construction in a historic district. You're reviewing an alteration to a contributing building in a historic district. You're reviewing an alteration to a landmark, designated resource. All of those are type 3 reviews because they require an evaluation of compliance with the guidelines and the criteria that are related to things like compatibility. That takes a lot of discretion to determine whether or not a particular design is compatible with its surroundings. And so Oregon City has delegated that task to you. And so there is notice to abutting property owners of the hearing that will take place before the Historic Review Board. There has to be a public hearing, and there are appeal rights to the City Commission. Type 4 Planning Commission quasi-judicial reviews are plan amendments. And they're plan amendments that are, let's say you were going to expand the Kanema Historic District by 2 houses. If you were going to expand the Kanema Historic District to designate 2 more houses, expand the boundary by 2 houses, you would go through a type 4 type 4 quasi-judicial proceeding. And you may say to me, why would that be quasi-judicial instead of legislative? Because we would be making policy. And the answer to that question is it has to do with the number of people who are affected. If you were going to create a new historic district that encumbered 10 city blocks, it would be a legislative decision because many people would be affected. And so you would process it as a legislative determination. But if you're only designating 1 house, you would have to have a plan amendment to apply the historic overlay to that 1 house, but we would have to treat it as a plan amendment that would have to go to the City Commission if there was an appeal. So that's how it breaks down. So type 4s are zoning amendments and map amendments that are small and particularized, and we provide quasi-judicial procedure to those because we want unbiased decision-making when it's one person affected.
Just real quickly, Carrie, just to remind everybody that the Historic Review Board policies are that administrative type 1. So if an applicant comes in, wants to get a building permit, and they meet the Historic Review Board policy on roofs, staff checks it, and then they move forward with the building permit.
That's a good addition. I'm glad you reminded me. I had forgotten about the policies. Questions about that? Okay, so let's talk a little bit in greater detail about the type 3 decision-making procedure. Again, the whole goal is to provide predictability and a level playing field for the participants to the process because it's a discretionary decision. So the code requires that an applicant meet with city staff and have a pre-application meeting to talk through what the proposal is, and so that the applicant can understand what code criteria apply and what needs to be submitted with an application. Does the code require a neighborhood meeting, or is that voluntary?
For Historic Review Board applications on its own, it does not, only if it's in conjunction with another project. So if you are a single-family home, you wouldn't be triggered, but if you're like a new commercial building, it's the commercial building that triggers the neighborhood meeting.
Okay, so neighborhood meeting is permissive depending on the project. So after that pre-application meeting, staff puts together pre-application notes that outline what has to be submitted with a complete application. And then an applicant files their application, and the city goes through a completeness review, which is a check-the-box exercise to determine if the application includes all of the things that are supposed to be required in order for the city to continue to process the application. It's important to keep in mind with completeness review that completeness review does not say the criteria are satisfied. What the completeness review says is you've submitted the things that are necessary to process an application. So for example, if the application material, if you got a new commercial building, you'd have to submit a traffic study. So the staff would say, yes, you have submitted a traffic study, but they wouldn't say whether the traffic study satisfied the criteria, right? Or in order to submit an application for new construction in a historic district, you have to have plans, right? But they don't say whether or not those plans show that the proposed design is compatible. All it does is just, it serves so that the applicant knows that the city is moving forward with processing an application. And once that completeness determination is made, the city under state law has 120 days to take final action on the application. So it also serves as a stick in the sand for starting a timeline for when the city has to take final action. And final action, just so you know, is the resolution of all appeals. So that is everything before HRB plus anything that happens on appeal to City Commission has to happen in 120 days. As part of once the application is filed and the completeness determination has been made, then the city staff puts together a notice of the hearing, and that notice gets mailed and posted in different places as specified in the city code, and that notice has to include certain things that state law says it has to include, which includes identification of the applicable criteria. That notice says the address of the property. It often includes maps of the property. It says what the proposal is. It says that a staff report will be made available 7 days in advance of the hearing, and it has to include the name of the person in the planning department that you can contact in order to get copies of the material. So it's very statutorily prescribed so that sufficient evidence gets out to the public, or information gets out to the public about how to participate in the proceeding. So 7 days before the hearing, city staff issues a report The report is city staff's evaluation of the application to determine if, in their estimation, it complies with the application complies with the criteria. The Historic Review Board is not bound by the staff report recommendation. All it is, the only purpose it serves is to help the Historic Review Board get a jump on an analysis of the criteria, identifying which criteria apply, and how staff interprets those criteria. Then we have the public hearing, and at the public hearing, we have to start every discrete review of an application with a series of disclosures, which is information that people who come to the hearing hear to know what procedures will govern the city's review. And in those disclosures, I could ask Chair Ferry to say what those disclosures are, but I will save you. Those disclosures say things like, tonight is the night for the hearing. You have an obligation during the hearing to raise all of your issues that you may have, because if you fail to raise the issues, you may not be able to raise them at the city commission. The whole idea is that you, as a participant, have an obligation to let the city know what your concerns are. You can't lay in the weeds and wait until the 11th hour and then pop out and say, well, all these things are wrong, right? We're trying to identify issues so that the applicant can adjust their proposal to comply with the criteria. We're trying to give the opponents an opportunity to understand what is being proposed and have a fair opportunity to know. So everybody has to raise their concerns before the Historic Review Board and come with the evidence. And so part of the disclosures is if you bring PowerPoints or you bring posters, you bring materials boards, you have to leave those with city staff so that they are part of the record, so that if you as decision makers want to look at those materials again, you can do that at any time, right? The record is all of the written things, all of the audio things, anything that comes in nonverbal form that becomes part of the file for you to review to determine if the criteria are satisfied or not. So it's really important that people know that when they bring audio-visual aid, any kind of visual aid, that they know they have to put that in the record. The disclosures also say that if you have constitutional concerns, you have an obligation to raise those. So those are included in these oral disclosures. You have a right to an impartial tribunal. So we'll go through what the elements of that are, but we tell the public that they have that right, and then they have the right to challenge any one of you for partiality if they at the right time. After we do the disclosures, then the applicant, we have a staff report. And so you usually hear a staff report where it's an oral presentation of what the written staff report says. And then the applicant gets an opportunity to present their case. And then oftentimes, that's after the applicant gets finished with their presentation. Sometimes the chair will take a testimony from proponents, other people who are in favor of the application first, or sometimes they just take general public testimony based on, we have cards in the back that people, when they walk in, they fill out if they want to testify. And so I'm not sure if, Kay, you call on people or if Chair Ferry calls on people, but one way or the other.
The chair would call on people, yeah.
Okay, so you call on people to testify and you organize it however you see fit. But you call on people to testify. It's up to the Historic Review Board to decide if you want to impose time limits on testimony, and you can decide that before. It's usually a good idea to decide it before you start the hearing based on how many people you have and how many items you have on the agenda, but it is certainly within the board's power to impose time limits as it deems appropriate. It's important to remember that those time limits, although they shorten people's oral testimony, people are welcome to submit written testimony of whatever length. And so I try to see it as, yes, you may only get 5 minutes to orally testify, but you have unlimited length to submit non-oral testimony. And that's what's necessary for you all to run your meetings efficiently.
Carrie, I have a question.
Yeah.
Script that I was given by the city, it does have specific times for, it lists specific times for people to testify. So is that something that we need, you're saying we don't necessarily need to times?
You don't have to.
Okay.
I think that's just a recommendation.
Okay.
And I think that the reason why, so we used to say, you might remember, we used to say, the procedures we will follow are on the board.
Yeah.
And then we didn't have a board for a while
it's
when we
still in
moved into
here.
this space. So that's why I think those were there.
Okay.
And I think the intention was that you would read the order of operations so that everybody in the room knows, okay, I go after the applicant, you know, so they kind of just know, have a visual idea of how the process will go. But you don't have to abide by those timelines.
Okay.
You at all. I mean, it's up to the board's discretion to decide.
Okay, thank you.
I also have a question. So the oral and written testimony becomes part of the record.
Correct.
If it is appealed, can the city commission take more oral and written testimony after that? Or is it limited to only what has been said during our hearing?
It is limited to only that which is presented at your hearing.
Okay. Great.
So it's called on the record, meaning the record is created before the Historic Review Board and it does not get enlarged again.
Okay, so it closes at the end of our meeting.
It
basically.
closes at the end of your review.
Okay, thank you.
In that, if after they've made something, we made a ruling or it's been presented, and we want to clarify or that the decision or add, if I say the word add, I'm just saying it's mostly just clarification. That's still capable.
So talk me through the steps of your hypothetical again.
It's kind of like if you're talking about if it is detracts from an adjoining property. If you get into the word of what is detracting, you can only say if it goes to the city commission, they can only apply the words that were actually used in the meeting.
No, you can only use the evidence.
The evidence.
The evidence. So if I'm an applicant and I propose a house and the Historic Review Board denies the house because it's not appropriate vernacular style, okay? And it doesn't, and I'm not willing to change the windows and change the elevations and all that stuff. So I'm not willing to change. So I get denied. I appeal that to the city commission. I can't change the design of the house because the evidence is closed. I go to the city commission, I argue that my house is a vernacular style, right? I can argue that at the city commission, but I can't change the design of my house.
Correct.
Evidence are facts. You can't change the facts after you get past the Historic Review Board. So that's why it's really important that when you all are deliberating, which this is what I thought your question was, Board Member Edgar, when you all are deliberating and you say there's some consensus building around a different roof height or a different window arrangement or a different porch design, I urge you to consider whether you want to reopen the record to allow the applicant to talk to you about that or the participants to talk to you about that because that way you get it in the record before. Because when I've watched some historic review board meetings, you all kind of decide, you know, these materials would be better. This citing would be better. You might consider, I mean, I hesitate to use such a simplistic example because your deliberation is never that simplistic. But when your deliberation involves multiple components of sort of changing a design, it might be worth, if you're not jam-packed with people, to call people up and reopen the record and have a discussion about that, so that you're not leaving people in a situation where they're appealing to city commission and they can't change anything. Does that,
Yeah. I think that sometimes the city commission might remand the application back to you if the applicant maybe is like, oh, I want to change it. So they always have the ability to send it back down, especially if the applicant waives the 120, and that sometimes happens where the applicant's caught in a place they didn't realize. I also recommend, I think this goes a little bit to what Board Member Edgar was saying, is, oftentimes the motion is you're adopting staff's findings as your own, but if there are 2 or 3 really important findings that the board really agrees on, then as part of your deliberations and motion, you can identify that. And in the notice of decision, I've often said, and the Historic Review Board also additionally found ... So it's like part that's adding to the record of the finding of the decision.
So you're suggesting, Carrie, that if that happens, and if we add 3 things, that before we vote on that, we bring up the applicant again, if they want to, and to accept that or not?
well, just to have a discussion about it, because what I think happens is you all decide you want these changes, and you haven't seen a design with those changes. You haven't actually seen those changes incorporated together. And, sometimes we're surprised after the fact that that's how the pieces came together. And I think if there's an opportunity for a discussion where the applicant either says, yes, I understand, or let me clarify to understand. You want this pushed back here and these columns here, and you want 3 here. And then that way there's a better understanding from the applicant's perspective. And if you want to see it, you want them to change the plans, ask them to go change the plans before you make a decision, because that's much easier to fix on the front end than to be surprised and have to come back again at the back end.
I see, so you're suggesting a continuation in the proceedings.
Perhaps.
If we reopen discussion with the applicant, do then we need to reopen public testimony? I know that sometimes we've had sort of controversial cases, and maybe reopening something is not necessarily the best or the most high.
Well, so the issue is a question of process at your level versus time, right? If you've had, so the first initial hearing, how the first initial hearing, anyone has a right to a continuance and they get it, right? So you've had that first hearing, let's say, and you've had a continuance request. So you're 30 days in at the second hearing, and they come at the second hearing and there's something that changes, right? And so you're faced with this question of, do I go to a third hearing, right? And because the HRB only meets once a month, that puts us like 90 days into the 120 days, and we still have to accommodate the city commission. So it's a kind of delicate balance of how much time we have. The other thing you need to know about the 120-day clock can be extended at the applicant's choice. So an applicant can decide to extend the 120-day clock at their prerogative. An opponent cannot extend the 120-day clock. Only the applicant can. So it may be that you say, applicant, would you be willing to extend the 120-day clock 30 days so that we can have a more open discussion about what I'm seeing the board, desire for these modifications to your design. And in my experience, if if applicants think you're working with them, they're willing to give you the time. If they think you're not working with them, or they don't want the changes, they'll just say, make a decision. And then, you've got to make a decision. But the other way you could do this would be a special meeting. We could have a special meeting if you're really feeling like, we can call a special meeting outside the normal once a month meeting, which could potentially achieve both ends.
Okay. And what are the sort of parameters of calling a special meeting? Does anybody in the board just say, hey, maybe this isn't working, let's have a special meeting, or is it a discussion with city staff?
It would be a discussion with city staff. I think it's that the board would say, I'm feeling like the applicant needs to revise these plans a little bit, and the applicant isn't willing to extend the 30 days. Can we call a special meeting? And then Christina and Kay, let's, pull up the city calendar and find a day that works for a quorum of you to be here. It can be done, in about 7 days' notice?
Yeah, I mean, we would continue to a date certain that we've identified at the meeting.
Okay, thank you.
So, quick question, I guess, in regard to that procedurally during the meeting, if the board decides to reopen the record to communicate with the applicant more, then is the chair bound to also allow any public comment relative to that? So in other words, if there's a lot of people and a lot of involvement, there may be more reluctance to take that course of action because you just kind of...
Yes. I appreciate that if the room is filled with 30 people, you're not going to be able to reopen the record and hear from the applicant and all 30 people again.
Yeah.
But what you might do is you could continue the hearing to a special meeting date or the next meeting date and allow all the parties to submit anything they want to in writing for the next 7 days.
Okay.
And so then everybody gets a fair shot at written whatever they want.
Mm-hmm. And
then the rules say that the applicant always gets an additional 7 days for argument if they choose. Because they bear the burden of proof, they're the ones that have to come with the evidence to convince you that the criteria is satisfied, they always get the last word. So in that scenario that I identified, you would leave the record open for 7 days to allow all parties to submit things, and then you would allow an additional 7 days for all parties to respond to things, and then you'd have to leave an additional final 7 days for applicant to have the last word because they're the applicant. So then you come back at your continued hearing, the record's closed. You don't have to hear from anybody. So I think that one of the things I've seen Landmarks Commission struggle with is moving the ball forward. Because if you just keep opening the record, you're just going to keep getting testimony. You're never going to move the hearing forward. And by actually concluding a public hearing and then leaving the record open, you come back and the record's closed. You're not hearing from anybody. You're going to consider the written testimony and make a decision. So that might be an option. Another way to look at it. But I think that, use staff as a sounding board about, they've been through all this before. So use us as a resource for how you might resolve complicated matters that require modification and tricky condition drafting and that kind of thing. Because the best case scenario is that you all feel confident about the decision and everybody feels like they had a say, right? That's the best decision you can make.
So just, I guess, maybe one or two more points is that if we're anticipating something that's going to be controversial or that we may have a lot of testimony on, the chair could reach out to Christina ahead of time, excuse me, and start talking about, strategy for how to manage the meeting. The other point is you can call a break or recess at any point in time and say, we'd like to talk to staff about, the next steps. So don't feel, like you can't do that.
Really good suggestions. Okay, I've got 15 minutes, I think, to cover about 2/3 of my slides. So I'll pick up the pace here. We've covered a lot of the stuff in these. So 120-day rule, I mentioned the city has 120 days. The applicant controls completeness. We just talked about that open record 777 process. The applicant always has the last word. I think I'm going backwards. Oh no, this is the various roles and responsibilities. I think we've covered a lot of the things in this too. The applicant has an obligation to show that, to provide evidence to prove that they're satisfied, right? The applicant has to design a building. It's not the board's job to design a building. It's the applicant's job to design a building. So if your feeling is that the building is too Victorian or it's too Art Deco, then you say to the applicant, go design a vernacular building that fits into the CANEMA design guidelines. It is not your, it is often helpful to the applicant if you design the building from the dais, but it is not your job to design the building. And so it is the applicant's job to provide you evidence that shows the standards are satisfied. It is the planning and legal staff's obligation to assist you in making a good decision, and that is to provide evaluation of the criteria to the extent it's helpful to you, to identify the criteria, to produce a staff report, to know what the code requires, and to be available as to respond to your questions either during the hearing or before the hearing. You are certainly welcome to reach out to staff with any questions you have before a hearing, and it can be a very good use of your time to help you understand exactly what is proposed. I don't know what I would do if I didn't call Christina the day of every hearing that I come to an HRB meeting and talk through what is proposed, so that because just looking at it on flat paper, it's hard for me to visualize. So encourage you to talk to staff because they are an amazing resource. Our job is also, as staff, is to protect a process, right? My job is to make sure that the process complies with the law, and so everything that we provide you as resources is to further an end of protecting a process to ensure that we're complying with the code and the laws. Neighborhood groups and others, the public is encouraged and should be encouraged to come in and participate in the process and raise concerns they may have about a design. I mean, nobody knows a neighborhood better than the neighborhood itself. And so they are invited to come and talk about projects and to share their perspective of how the criteria should be applied in any case. As the decision maker, the Historic Review Board's job is to interpret and apply the plan and regulations based on the language that is set forth in that plan and regulations, and not to make a decision based on whether or not you like the person who's applying or not, or because you happen to like greenhouses, or because this person happens to make the best banana bread on the block. We approve applications because they comply with the criteria, and that's what the job is. And you all know that already, so I don't have to belabor the point. We encourage you to do your homework. You will have the most success at hearings if you are familiar with the materials and can ask questions based on your review of the materials. In advance, the meetings run much more efficiently if we have a decision maker that has reviewed all the materials and we're all sort of talking at the same, about the same evidence. Be courageous and don't be afraid to ask questions of the parties. Don't be afraid to ask questions of your fellow board members. I mean, the reason there are 5 of you is because you all have different opinions. So if we wanted only one opinion, we'd have only one member. So we want you all to discuss and feel confident to ask questions and be wrong sometimes and be right sometimes, and that's all part of the learning process. I mentioned that applicants and participants, all participants, not just applicants, have a right to an impartial tribunal. That means that there are no ex parte contacts. An ex parte contact is a communication that happens outside of the public hearing process. So these are circumstances where you as a decision maker receive evidence outside of the materials that are in the written record or that happen inside this room when you're hearing matters as a historic review board member. So this is a person comes up to you in the grocery store and says, hey, have you heard about that new house going on this street? It's a terrible thing. You should vote against it. That is an ex parte contact. That is somebody lobbying you outside of the process and potentially giving you evidence and coloring your judgment about an application. The same is true with newspaper articles. Same is true with Facebook posts, any blog things you get, anything like that. Those are all information you get outside of the hearing process. And those ex parte contacts have to be disclosed in the record so that the parties to the process know that the ex parte contact happened and they know that that evidence is out there. So if someone comes up in the grocery store and says, this house is more than 35 feet tall, you have to come to the hearing and say, I ran into Jane Smith at the grocery store. She said that this project is more than 35 feet tall. And then as the applicant, I can come in and explain to you why my plans show that my project is not more than 35 feet tall. So that's why it's really important. The easiest way to disclose ex parte contacts is to document them when they happen. So sometimes you may get emails from neighborhood groups who are concerned about a project, and so that would be an ex parte contact. And so what you do is you forward that contact, that email to city staff, and they'll put this email in the record. If you read a newspaper article, I mean, you should read the newspaper, right? We want informed board members. If you read a newspaper article about a project that's coming before you, you just forward the copy of the newspaper article to staff and put it in the record, and then all is forgiven, right there. You don't go to HRB jail for having an ex parte contact, right? What happens is you have to disclose the contact so that it is cured, so that people have an opportunity to respond. So that's how ex parte contacts work. A site visit, if you go to the site and even if you drive by, that is also an ex parte contact because you have an opportunity to get information, evidence that is not part of the record. So when Board Chair Ferry does the disclosures, she will ask, has any board member had any ex parte contacts? And then sometimes I'll do roll calls, sometimes you just, go in order, but you disclose, did you make a site visit? Yes, I made a site visit, I drove by, and what did you take away from that site visit? I took away that the slope is much steeper than I thought. I took away that there's a non-conforming house right next door that's very modern. I took away that there are 3 contributing structures right next door to this, and they're all this style, and they're all uniformly set back. I took away that, whatever sort of evidence you get from that visit, you want to put on the record during your time, during the hearing, and then after everybody has an opportunity to disclose their ex parte contacts, the chair will ask if anybody in the public wants to question the board members about these comments. And then that's an opportunity for people in the audience to come up and ask further questions about what those contacts may be. Not to argue the merits of those contacts, not to argue about whether or not the building's actually 35 feet, but to ask you, when you said that it was a very steep slope, how steep of a slope did you think it was? Or would it help you if I put photos in the record? The question, the reason for the opportunity for the public to comment is to get from you more evidence to make a determination if all of the evidence is out there. I don't know if you've ever had anyone come up and question a commissioner. It doesn't happen very often. The other thing that impartial tribunal assures, guarantees, is that you will have a decision maker that's free of actual bias. Actual bias exists if a person is unable to make a decision based on the applicable approval criteria. You know, if there's a house in a neighborhood that you've always loved and it is your favorite house and there is absolutely no way you could ever allow anything to happen to it. I mean, there are houses I live in Portland, that I just love, and I could never, ever, ever approve an addition to those houses, ever. It wouldn't even matter what it's made out of, because I just love it so much. Doesn't matter what the criteria are, I just love it so much. Those cases, I would be a biased decision maker and I wouldn't be able to sit on the decision. And everybody has biases. And it's part of life, and you know, I find it refreshing when board members come to me and say, this is coming up and I can't see past my own feelings about this particular structure or this particular applicant or this particular, I've never liked this guy. Doesn't matter what he might propose, I've never liked him. So don't participate in those decisions. And when those come up, reach out to staff and we'll help you decide whether or not this is something where, you know, it would be better for you to step down. And that's why we have 5 of you, so we can afford a couple spares. Questions about that? Finally, you can't have any actual conflict of interest. A conflict of interest is a fiscal benefit that you would realize as a result of an approval or a denial. And that fiscal benefit not only runs to you, but it runs to your family members too. And if that comes up, staff can help you work through those issues as well. Okay, there are some other quick government ethics issues. You can't use your public position to obtain a financial benefit. So you can't, you know, call the city's 4th of July festival and say, hey, I'm on the Historic Review Board, I'd like front row seats, please. You know, that's just not allowed. You can't accept gifts in excess of $50 per year. So no allowing your neighbors to take you to lunch to try to help grease the skids for their proposal, right? And it's important to know that these government ethics issues carry with them personal liability for violations, and there is a state agency called the Oregon Government Ethics Commission, whose job it is to help appointed and elected officials get through these kinds of ethics issues. And so we all know how to reach the Government Ethics Board and can help you if you have any concerns or questions about that. But I think Jacob also does a little bit of training to each of you when you start out about this, so I think that he'll be able to supplement. He's the city recorder. All meetings of the Historic Review Board are protected by public meeting law. And public meeting law is what is sort of the government in the sunshine rules that makes the process transparent. And so we have to comply with these laws. They require a majority of a quorum make a decision on an application. So that is 3 of you right now. Is that right? So in order to have a public meeting, we have to have 3 of you present. So you all can't go on vacation at the same time. You can, but you can't miss the last Tuesday of every month, right? So we need to have at least 3 of you present to take any action. We have to take minutes. We have to record the meetings and keep them as public records. It's important to know that a public meeting is different than a public hearing. A public meeting is when you all meet to conduct business of the city. A public hearing is when you have an application before you and you're going to hear from the public about a particular application. So oftentimes I hear people confusing those terms, those two, and they mean different things. You could have a public meeting and not take any testimony at all. If you were going to have a work session to decide whether you want to change the code, that would be a public meeting, but you wouldn't necessarily have a public hearing where you would take testimony. We have an obligation to maintain public records, so any writing or data, computerized data that is relating to city business, we have to maintain as public records. And what this means is that your emails relating to city business are public records, and that is why you all have Oregon City issued email addresses, and we encourage you to use those exclusively for city business and keep that separate from your personal email and your personal business, because if we were to get a public records request asking for all the documents related to a particular application that you all reviewed, we have to go in and be able to search your email, and we want to be able to just search your Oregon City email address and not your personal email address to turn over materials. The other thing I want to make a note about public records is that the notes you take during a meeting can also be public records. So be careful if you're like working on a shopping list or your kid's Christmas list as you're listening to a meeting because during a public hearing, because someone could make a public records request for those notes, and we would have to turn them over even though they don't have anything to do with the application that was before you. I've got a slide here about sort of hearing issues, and my sense is that you don't have disturbances where you have to call security, but that has come up in public hearings in other jurisdictions, and what we try to do is encourage the chair and the board members to work together to deflate any conflict, to discourage people from cheering or jeering or talking out of turn. If people want to talk, they have to be recognized by the chair, and they have to come up to the desk here and speak into the microphone, because we have to record the meeting, and if they sit in the back and yell and scream, we can't record it. If there were ever any sort of controversy, consider taking a break, calling a recess, allowing everybody to sort of reset, allowing you all to take a break and sort of adjourn. I don't know if you were in virtual, if you took breaks too often, but now that you're back in person, take advantage of breaks when it's helps the meeting flow a little bit, and it sort of can help break the tension. So we're past taking testimony, and now we're to the deliberation and the decision. I told you the applicant has the burden. Your job is to first identify and interpret the approval criteria. And interpreting the approval criteria is a difficult thing to do when the standards are highly discretionary. For example, I quoted one of the criteria here. The general compatibility of the exterior design, arrangement, proportion, detail, scale, color, texture, and materials proposed to be used in the construction of a new building or structure. So that's pretty wide open. And so you have to decide what your measure is going to be. Is your measure going to be what you can see from the street? Is your measure going to be the whole district because of where you can, what you can see? You have to be able to come to agreement on what the measuring stick looks like before you can decide whether the evidence meets that stick. And so it's defining what your measuring stick looks like. And you should be informed on these highly discretionary criteria by the comprehensive plan policies that talk about encouraging the preservation of historic structures. So we're trying to maintain the visual continuity of a district. Right? A district works all the little units together as a whole, right? So if we have too many holes in the Swiss cheese, it's not really Swiss cheese anymore because we have lost the cheese. So we want to try to maintain the cohesiveness of the district as a whole, I think, is the general school of thought on how compatibility works for a district. you know, but we also have comprehensive plan policies that say encourage, you know, property owners to maintain their buildings. And if we make it so onerous that no one will want to own buildings in historic districts, then we sort of open up the district to vulnerability, right? We have to allow some flexibility to allow people to modify and change their buildings. So it's a balance. And you should be informed by the design guidelines. You should be informed by the comprehensive plan in how to interpret those criteria. But it's not an easy job. And for those of you who've been here for a long time, I am so pleased that we haven't seen very many historic review board appeals. And that's a testament to the good job that you are doing with interpreting the criteria. After you've interpreted the criteria, you've got to identify the facts in the record that lead to a conclusion that the criteria is satisfied or not. So here's where you say, I'm looking at the plan. We decided that the building needs to have you know, reflect vernacular or arts and crafts detailing, and I'm looking at the plans and I'm seeing a porch here that reads more Victorian, or it's not symmetrical, or it should, you know, it's too wide and flat and not tall and skinny, or whatever you're seeing on the plans. That's an evaluation of the evidence to the criteria, and that's really critical to the job of the HRB. If you find that a criteria is not applicable or satisfied, you have to explain why it's not applicable, or you have to explain why it's not satisfied. And that narrative, that explanation is called findings. And findings have to be adequate in order for the decision to be defended if it gets appealed. And that's why the staff report provides an initial set of findings, and if you agree with the staff, you adopt the staff report decision as your decision. But of course, you can modify that, and that's why Christina suggested you could modify the findings with respect to some elements if you find that the standards are not satisfied with those in those respects. Where there's conflicting evidence, you as the decision maker get to decide which conflicting evidence to believe. And the standard of review that the Land Use Board of Appeals would use in evaluating your review of the evidence is whether a reasonable person could look at the evidence and draw the same conclusion. So that's the standard of review. Conditions of approval, there are some constitutional limitations on your ability to impose conditions of approval that have to do with the extent to which the condition relates to the impact from the development. So, for example, the city couldn't require an applicant to build a 4-lane road in front of their house, in front of their new house proposal, because their development doesn't need a 4-lane road. Their development needs a local street. So there are limitations on how the city can impose conditions. I don't think this comes up too much for HRB because you're more interested in design, and a proposal puts forward a design, and then your job is to evaluate it for compliance. So if you were to change the siding to smooth siding instead of textured siding, that wouldn't raise constitutional concerns because that's something the applicant is proposing. Final slide, I promise. Okay, these are just some of my takeaways that I've seen to be helpful for effective participation. Try to avoid ex parte contacts or receiving evidence outside the record. If somebody comes up to you and says, hey, I really hate this project, you stop them and say, I really appreciate your feedback, but I don't want to hear it right now. Please come to the hearing on Tuesday night at 7 o'clock and we'll talk about it. So you don't have to discourage ex parte contacts, but in my experience, the process works smoother if you do. Be attentive and prepared. Don't be afraid to ask questions. don't make any assumptions about what you hear. I really appreciate when I hear decision makers say, okay, I'm looking at you're in sheet A2, and what I'm hearing you say is this. Is that a correct understanding of what you are saying? Ask an applicant to confirm before you accuse the applicant of not satisfying something, because then you're showing a willingness to listen and learn before you presume anything. Don't make up your mind beforehand, avoid prejudgment, and again, don't be afraid to disagree. There is, at the back of my PowerPoint here, there is an Oregon Land Use Training video that was put together by the Land Conservation and Development Commission a few years ago that you might find helpful. This is the link to the Oregon Government Ethics Commission guide. And then here's my contact info, and I'd be happy to answer any questions or comments. Sorry, I went over.
And just so you know, I just emailed you this presentation, so you have it.
Thank you very much.
I'm fine, thank you.
Okay.
Sorry, I kind of talk fast.
I'm fine, thank you.
Don't worry, I'll be back next year. Hopefully.
All right, so I believe that now concludes the legal training, and we will start our meeting soon.
Thank you.
Thank you.